here at the University of Bergen and a part of the law transfer team. I have the pleasure to moderate the first of 3 roundtables this morning on different issues evolving around children's rights. I'm so happy to see so many of you this early on our final day. And I hope you're ready to ask engaging questions after we've heard our 3 amazing panelists. So in this session, which is called the European Court of Human and Children's Rights, our 3 panelists will address topics and questions posed in the book project on the European Court of Human Rights and Child Protection. The book is exploring how the European Court of Human Rights plays a role in the development and contestation of child protection and children's rights as they are laid out in the Convention on the Rights of the Child, the CRC. The background for the book project is the wave of cases against the state of Norway concerning child protection brought to the European Court of Human Rights, 49 in total, in which Norway was found in violation of human rights in 14 of 21 cases that was decided on the merits. And this statistics makes actually Norway #1 of the states in which the court have found violations on child protection cases. So quite interesting. The book project is a part of a research project at the Center for Research on Discretion and Paternalism, DIPA, here at the University of Bergen. In this first presentation, we'll hear 3 presentations. I'll introduce them soon, and then I'll open the floor for questions immediately. So we have like 45 minutes. Our first panelist to present is Hege Stein Helland, which is a postdoctoral researcher at DIPA. Hege holds a PhD in political science, where she focused on discretionary decisions and justifications for the adaptation of foster children in Norway and the UK. I hope that's correct. Yeah. Elaine Sutherland, she's with us digitally on screen. I hope you can hear us, Elaine. Yeah. Elaine is a professor too at DIPA and a professor at the University of Stirling, Scotland. It's an honor to have Elaine here. She's an expert internationally recognized on children and family law and the author of 100 articles and book chapters and 6 books, and the editor and co-editor of 9 others. So fantastic. Our final panelist to present is Asgeir Falk Eriksen. He's an associate professor too at DIPA and a senior researcher at Oslo Metropolitan University. On your website, it says that among your research interests are political theory, trust theory, public administration, and politics of family and child protection. I hope that's correct. And he has published several articles, book chapters, and books. So, Hege, I give the word to you first. Yeah.
I'll try to sit close to the microphone.
Yeah.
Yes, so as Marte mentioned, there has been a landslide of cases concerning child protection in the European Court of Human Rights since 2015, with then allegations from mainly parents that their Article 8 on the right to private and family life has been violated by the Norwegian state. So, as Marte also mentioned, there has been violations in 14 of these cases, and 2 of them have also been decided at the very top of the system, so at the Grand Chamber. So, suggesting that these are cases of high importance and also precedent setting. The most common case is the Sandloppen versus and others, which some of you might have heard of. It got a lot of media attention. So just very briefly about these 14 cases. They are, of course, different in nature and address varying issues, but in all essentials, the majority of cases, they concern care and contact arrangements and also non-consensual adoption of foster children. These cases were also often seen in relation to how the cases were decided. So very early on, they were said to be long-term. So when the child was placed, they were said to be there for a long time. And so the cases were kind of locked into a certain outcome. What's the argumentation? The court was also critical, especially in this famous Van Lobben case, that there has been insufficient balancing of interests, so between children and parents, and so kind of implying that there has been a skewed argumentation and that children has or there has been too much weight on the child's interests in these cases. There has also been some critique on procedural matters, but all in all, the decisions themselves, so the decision on care order and adoption has not been criticized, and the national legislation has also been found to be in accordance with the convention. So what I have done and what I will talk briefly about today is I've studied how these judgments have impacted decision-making at the street level. So in social work or child protection agencies in Norway, talking to managers and also surveying social workers. Yes. So I wanted to say something firstly about the domestic impact of this kind of human rights litigation, but I also wanted to look at the implications such kind of massive legal pressure has on children and the protection of their rights. So very briefly, what I found is that it has had a great impact on the decision-making in the first line. So on the one hand, the decision makers, they see this as a positive thing. So it's actually quite well received, and they see it as kind of bringing in a necessary adjustment to their practice. So they highlight this themselves, and there appears to be some of the impact it has had as positive effects on the protection of children's rights, such as, for example, having better work methods for assessing their work and how they document this work. So this is according to themselves. It is not any empirical study of what actually is done. Moreover, a lot of them also say that these judgments have been kind of a wake-up call. So they've been kind of dragged out of habitual practice of what they used to do. So they're kind of forced into seeing things differently. So how when they, for example, or this is specifically related to contact arrangements. So before it was done more mechanically. So okay, this child is long-term, then we give this and this much contact. That's what we usually do. And there was not, they're kind of admitting themselves that, okay, maybe we didn't do kind of individual assessments of this, and we were critical about this. Although there are some concerns that we're just creating new standards. So the old standard was 4 to 6 times a year. Now it's 12. So some things don't really change. So these are then all aspects that can contribute positively towards kind of the protection of children's rights and their legal safeguards. But then on the other hand, there are also concerns related to the judgments and the impact that they have had that are more on the negative side when it comes to protecting children's rights. So the judgments have also, especially on the street level, on the decision-making level, there is quite a lot of both intended but also unintended consequences, and also quite a lot of indirect consequences. So at the general level, or just the general kind of how these judgments have been received in the sphere of children's rights, there are quite a lot of people that are critical towards the judgments. And one of the things is that the child does not have kind of an independent presence in these judgments. So they are just included as co-complainants alongside their parents. Also, some studies have found that their opinions are by all means absent. So there is very, very little of what the child actually means and thinks about these things, which is not in line with the CRC, as mentioned. As a more general argument, it has also been said that especially some of them, but also some of the other judgments are representing a setback for children's rights because the court is no longer seeing the child's interest as paramount, which they used to do. Yes. So what the professionals working with child protection in Norway say when I talk to them is that even though this has some positive effects, so they are also concerned about the development that is going on. So this is especially related to what we often call the pendulum effect. So there has been this kind of shock to the system, and so everyone's just throwing their hands up, and so we have to change, and they kind of have to make some rapid decisions and adjustments. So it shifts from one side to the other, and now we are probably seeing a move towards a more restrictive practice where that might not be too deliberate. So what they say is that they are concerned that this has caused kind of decision-making to focus more on parents on the expense of children. So while it is a good thing that parents are also seen more, it shouldn't kind of be on the expense of children's interests. The concern they raise most often is about contact. So they are worried that children are getting too much contact with their parents, and even though it might not be in their best interest, because that's what we do now. There is also indications there, or it's not even indications, we know that the thresholds for care orders and adoptions have been raised. So even though, as I mentioned, the court has not criticized the law, they have not criticized decisions themselves, but we see that the thresholds have been raised. So this is not necessarily or in itself a problem, but it is a problem when if children are not getting the services and help that they are in their best interest and that they would that they have a legal right to get because one is scared or is misinterpreting case law. And I just want to stop with some statistics because the numbers also tell a story and kind of backing this argument about the threshold. So since 2018, the Grand Chamber judgment was in 19, but there had already been kind of some judgments and a certain development. The number of adoptions from care without consent in Norway was 73, so quite a low number, but still. And then it has dropped to 11 in 2021. So that is a reduction of 85% in 3 years. We see a similar drop in care orders in also a 3-year period. I think it's a 45% reduction. So this is drastic changes, which is implying that the Norwegian Child Protection is moving towards a more restrictive practice. But I also hear from managers that they are seeing some kind of better destabilizing a bit. So perhaps ending on a slightly positive note, but yeah, we'll see.
Thank you very much again. Very interesting. Elaine, then I give the first you.
Right. Well, good morning. Can you hear me clearly?
Yes.
Yes. Well, thank you, Marta, for that lovely, very generous introduction. I'm delighted to join you today. And I only wish I could be there with you in Bergen, but I am using my CMI coffee mug, which is the closest I can do to becoming part of things. Well, I think as we're probably all familiar with, all European countries, and indeed most countries around the world, accept that the state has a responsibility to protect children from abuse and neglect. But when the state intervenes in the family in order to protect a child, it's facing something of a damned if it does and damned if it doesn't kind of dilemma. It may be accused of overzealous intervention if its actions are thought to be excessive or unwarranted. On the other hand, it'll be condemned for a failure to act in a timely and appropriate manner, particularly if a child is injured or dies. And perhaps one way to test the legitimacy of state action is to compare it with international human rights standards. In Europe, the two main sources of these standards are the European Convention on Human Rights, as interpreted by the European Court, and the United Nations Convention on the Rights of the Child, CRC, as amplified by the CRC Committee. But the problem is that testing against these norms can be difficult if either the treaties themselves or the way they're being interpreted and amplified are inconsistent, because that's going to leave the state either unclear about what it's supposed to be doing or unable to satisfy all of the norms simultaneously. So this morning, my focus is on the priority being given to the child's best interests under the European Convention and under the CRC. So turning first to the European Convention on Human Rights, Haga has just done a superb job of summarizing, repeat all of that. Perhaps the clearest thing that I can say is that the message from the European Court is very much that when taking account of the child's best interests, there must be a genuine attempt to balance those interests alongside the rights of the parents. So what we're talking about here is a balancing test. Stating the obvious to say to the European Convention, the CRC is wholly child-focused, exploring various aspects of children's rights. But in doing that, the CRC is at pains to acknowledge the importance of the family. It does that very explicitly in the preamble and in numerous other articles. So, for example, Article 9.1, talking about the separation of the child from the family. Alongside that, though, it acknowledges that some families will not be able to provide for the child, and indeed that some are the source of harm. And it places the state under an obligation to protect children. And again, lots of articles on that. For example,
Elaine,
3.2 CRC have to say about priority.
Elaine,
Sorry?
I'm really sorry to interrupt you, but the line is a little bit unstable. So I was wondering, maybe we should try to turn off your camera. It might be better. Yeah. Would that be okay?
Turn off my camera.
Yes, would that be okay? Because then I think the line might be a little bit more stable.
Right. Okay. Now, I would be very happy to turn off my camera if somebody could tell me how to.
I think we have one here that can help you now. Okay. So I think the camera is off. So maybe you can, and maybe you can turn off the volume on a little bit more. Okay, Len, we try again. You can continue.
Okay, that's super. I'm awfully glad.
That's much better.
Oh, good. I'm awfully glad somebody was able there to turn the camera off, because I'm not terribly sure how to do it. So did you all sort of pick up? Was it clear when I indicated that the real message from the European Convention is that we're talking about a balancing test?
Yeah.
Sorry, yes, from the European Court was that we're talking about a balancing test. Turning to the CRC, what does it have to say about priority to be accorded to the child's best interests? Well, the starting point here is one of the Convention's fundamental principles, Article 3.1, which makes the child's best interests a primary consideration in all actions concerning the child. And the CRC committee has gone on to amplify that through the various mechanisms it has. Two can be dealt with very quickly. One way it amplifies the convention is through concluding observations on the reports that states parties have to submit every 5 years. It's sort of the committee's report card on the state's performance in terms of implementing the convention. Well, in these concluding observations, the committee always emphasizes and reminds the state party how important Article 3.1 is, that it, is really central and crucial. But thereafter, when you look at the concluding observations, it does not really squarely address how you balance best interests against parental rights in the child protection setting. And the reason why it doesn't go into that in any great detail is probably because concluding observations are subject to a word limit and they have to deal with a lot of different things. So that's concluding observations. Another way that the committee can amplify the convention is through the complaints procedure under optional protocol 3, the third optional protocol. The difficulty there is it has not yet decided any child protection cases. So it's again just not had the opportunity to do it. Now, there are some child protection cases pending, so there may be a bit more insight coming there in the future. It's when we turn to general comments that we get much more helpful insights from the committee. And particularly helpful is general comment number 14, and that's hardly surprising because it deals specifically with the primacy of the child's best interests. And there the committee goes into a lot of detail about what's meant by best interests, how it should be assessed and how it should be applied. Like the convention itself, general comment 14 emphasizes the importance of the family, as well as the importance of protecting children. When it turns to the idea of there possibly being a conflict between the child's best interests and the rights or interests of someone else, that's when we get the more helpful stuff. The committee, first of all, recommends that there's a genuine attempt to find a compromise, but it also accepts that's not always going to be possible. Where compromise is not possible, the committee is absolutely clear, paragraph 39, that the child's best interests have high priority, that they are not just one of several considerations, and consequently that, and again I'm quoting, a larger weight must be attached to what serves the child best, end quote. Well, that's very different to a simple balancing test as required by the European Court. So it does seem that where a state is a party to the European Convention and the CRC, it is being sent a mixed message about where the priority should be in respect of best interests. And that clearly is a rather unsatisfactory state of affairs. So what can we do about it? Well, I think it's worth bearing in mind, and this will only work if that continues to be true, the European Court attaches great weight to the CRC. It gives it sees it as very important. Well, that being the case, One way forward might be for the CRC committee to draft a new general comment on child protection. And obviously it would deal with a whole range of issues. But one of the things it could address absolutely squarely is the priority to be attached to best interests where it conflicts with parental rights in the child protection context. Now, were the committee to adhere to the position it took in general comment number 14, that greater weight has to be attached to best interests, it might cause the European Court to revisit the matter and possibly revise its own position. And with that all to work, then the stars would be in alignment. Of course, there's no guarantee that would happen, but I'll just leave you with that thought. Thank you.
Thank you very much. Very interesting on the relationship between parental and CRC. Very fascinating and challenging legal questions. So I give the floor to you, Oscar.
Thank you. Yes, jumping a bit in topics here. Sorry. I'm going into the legal profession populating report. So at the heart of the search for understanding what rights mean and how they work is the professional discretion of the legal profession. That is, in lawyers, judges, and other legal practitioners who make the wheels of the court turn. Discretion in this context extends beyond mere choice of preference. It is a judicious application of knowledge, experience, and ethical considerations in navigating the vast and often intricate landscape of law and its domain. Discretion is thereby a hallmark of the professional practice of the legal profession. It is a hallmark of professions per se, but also that of the legal profession. What is involved is that when general rules do not determine unambiguous conclusions about what ought to be done in particular cases, there is a space for discretion or professional autonomy of the single professional to perform professional judgment and decision making. Discretion becomes an area where the professional can choose between permitted alternatives of action based on the professional judgment. To the European Court of Human Rights realm, and with a doctrine called the margin of appreciation, built into it, which we will return to, discretionary competence becomes wide. And there is a risk that how one legal professional conducts discretion would be different to the next. To fully appreciate the depth and breadth of discretion, it is essential to understand its foundations. Law is not just a set of rules and regulations, it is a living, evolving entity shaped by societal values, historical precedents, and philosophical underpinnings. This is where theory enters the picture, and with its answers to what law is and is supposed to be. Theory offers legal professionals a lens, a way to interpret and understand and apply the law. Whether it is consciously acknowledged or not, during practice, the epistemological bedrock of legal practice is deeply intertwined with theoretical perspective. For instance, when a lawyer argues that a law should be interpreted strictly by the wording, they are alluding to a formalistic or journalistic or positivistic standpoint. For instance, conversely, when a judge considers societal implications and practical outcomes while making a judgment, they may touch upon legal realism or pragmatism. In essence, every legal decision made by a legal professional, whether made in a courtroom, a law firm's conference room, or chambers of a legislative body, is an act of discretion mitigating between stipulations on the law itself, the complexities of the situation at hand, and the theoretical knowledge of the law that the legal professional activate to perform decision-making, reaching judgments, and so on. In this effort, a professional aligns with a theoretical framework, as they implicitly yield some type of answer to what law is. To illustrate this point, we can go to how the judge in a human rights court understands the margin of appreciation doctrine in concert with their job of enforcing human rights. The conception of the margin that different theories agree on is the one that is quite bluntly in the preamble to the European Convention on Human Rights, and which stipulates the margin as a necessity for the European Court of Human Rights to have each country to act on decisions they make to enforce the rights to state sovereignty, completely depend on that infrastructure. However, adding a theoretical understanding of the margin on top of that would make the margin mean something different depending on the type of theory the legal professionals subscribe to. It can be a margin that is flexible and adaptable, but also a conservative and rigid margin. The argument then would be that depending on what theory a legal professional aligns with, the different understanding of the margin would give different answers to what constitutes, for instance, the child's right in any given case. The theoretical approaches often inform the choices made when performing discretion in how to interpret the law, how international law works through the margin, which aspects to emphasize and which arguments to foreground. The margin of appreciation in this light becomes a space within which professional discretion apply definitions and meanings to what the margin means. Now, what would happen if you channel the human rights court through a positivist approach to the margin or through the prism of legal realism? Now, legal positivism emphasizes a clear demarcation between law and morality, which has profound implications for the profession. At its core, the positivist perspective suggests that the validity of law originates from the recognition legal sources received by those who must live by, the citizen, rather than its substantive or moral content. It can be about anything, as Kelsen said. This delineation gives legal practitioners a structured legal approach with a priority on clarity and predictability, which it holds to that the authority of law can provide. Consequently, the margin of appreciation is approached cautiously, and the room for discretion becomes restricted by the rule of law emanating from the constitutional arrangement within the specific country, the applicant country. Hence, to a positivist, the guiding compass is the domestic foundational norms, such as a country's constitution. The margin is thereby conditioned by each country's potential and capability within their respective established rule of law within each country. To this end, the rights of the child's potential are within what each country has as a capability, and where decision-making of the court abides by the respective country because this is the jurisdiction where citizens recognize the validity of rule of law, that is, its authority. For instance, if a country's constitution doesn't recognize a particular human right that an international treaty seeks to protect, or the rights of children are not embedded constitutionally, or that it conceives of a human right in a manner that is in conflict with other countries or an international court, a strict positivist might argue that the treaty's provisions are secondary or even irrelevant in their jurisdiction. This underscores a profound challenge to the cosmopolitan ethos of human rights. However, it can also explain why, for instance, Norwegian Child Protection services have been notoriously on the dockets in Stockholm since the rule of law in Norway is claiming to be and striving to be aligned with human rights that the court must enforce. So turning to legal realism, which is another theory, it offers a marked departure from the formalistic tenets of positivism, asserting that laws are far from being isolated as autonomous rules and deeply embedded within and influenced by sociopolitical context. This perspective contends that laws function as tools or instruments, serving broader societal ends rather than mere formalistic regulation. When approached from a realist perspective, the marginal appreciation is not merely a procedural mechanism, but a reflection of the interplay between law and its surrounding societal context. The margin thereby becomes much more comprehensive than compared with the positivist approach. In international law, a legal realist would approach the margin of appreciation with a keen eye for its practical implication. Instead of strictly adhering to the literal interpretation of international treaties and norms, the practitioner might give weight to a particular decision's broader sociopolitical realities and implications. This emphasis on the instrumental nature of laws might make the legal professional more adaptable and responsive to the ever-evolving socio-political landscape. However, herein lies also a potential pitfall. While adaptability is commendable, an overemphasis on sociopolitical approaches to build on can lead to inconsistencies in decisions across similar cases, and that equal clients are treated unequally, depending on what courtroom they are in, depending on what judge you get and what that judge leans into with respect to extra-legal knowledge to inform the decision. In this manner, the rights of the child can become dominated by different strands of schools of thought from other disciplines like psychology, or thought depending on the choices of inclusion by the court. Now, these are two legal theories picked up a bit by random, but they are quite large. And there are many others, and we are left with a variation crossing all the places a legal professional received its education, conducted its practices, and so on. From a human rights perspective, this frustration is that both of these mentioned theories allow for arbitrary enforcement of human rights. We know why we have human rights, we know what they imply, or at least know-ish. We have a certain idea that it, for instance, involves the dignity of the person. Positive doesn't actually care about that in a strict sense. If human rights were to become a guiding theory on understanding the margin, it would imply a push for higher integration of legal culture across countries. I think I stopped there.
Thank you very much. Very interesting. I think it made a natural follow-up from Elaine's presentation. And it's also interesting as a lawyer to hear these theoretical deliberations. In Norway, in our education law faculty, we're not very concerned with theory, so it's interesting to hear. So I'm gonna open the floor for questions now. We have a box, a microphone around. So there's one there. We're throwing the box. So when you
I don't think anyone wants me to throw the box. So my name is Catarina. I'm from Brazil, but I live in Norway, but I'm not very familiarized with the Norwegian system. I'm a lawyer as well, but you know, we have a high emphasis in theory in law school in Brazil, and I teach jurisprudence. So it was interesting to hear. But I was just wondering if you could expand a little bit more on the responses of the Norwegian state to the cases, because I think not all of us are familiarized with the details of the case. So I think when I first came to Law Transform, I was a bit baffled by perhaps some people saying, very concerned as that the courts were not going in the right direction. And that struck me a strange note, because I don't know, maybe because I'm an immigrant, right? So I was like, I was thinking, oh, maybe the state is abusing its power. So, I mean, maybe that's where I come from. We don't trust the state very much. So we always tend to probably see the state as potentially abusing their power. So if you could just explain, because I think the Norwegian case, it's very subtle, and for people that are not so familiarized, perhaps it will clarify certain points. And then the response. So what is happening a little bit more? I know you touched that on your, but you said there were unintended consequences, indirect. Maybe what were these consequences, so that we can paint a more clear picture? Thank you.
Thank you. So what was really interesting is when you speak about the best interests of the child, that becomes another black box. Who defines and how is it defined the best interests of the child? Because surely there's enormous amount of discretion on the state's behalf to decide exactly what are the best interests of the child. Some might argue the best interest is to keep him together with the family unless X level, in which case they shouldn't be with the family, right? So who gets to decide that?
Okay, so we can go back. Yes, we start.
I can try.
Yeah.
As regards to the last question, it's definitely this is the core of the difficulties of the best interest of the child, that it depends on the definition of what is in the child's best interest, and also it will and that is probably at core of a lot of the decisions also, that there is a disagreement in what is the best interest of the child in these cases. So I do not have the answer. And if I did, I would probably be somewhere else preaching this. As to the first, I'm not entirely sure what the question was, but the responses of the Norwegian state. So they have made some formal responses. They have made some efforts to kind of accommodate the criticism by they had what's it called, like yeah, they've made expert reports. They've paid the what's that called? Like they paid money. They were said to pay money to the victims in the case. Yes, reparations. I don't have a full kind of overview of what they've done. But the general, as I mentioned, is that people agree with parts of the criticism, but then it's probably also this feeling of that it's a bit unfair, that they're not understanding. But then again, some of the criticism is kind of widely accepted as legitimate and necessary. Please.
Perhaps just ask if Elaine wants to pitch in before I start.
Yeah, Elaine, so maybe you would like to say something, especially on the last question, but please go for both if you want to.
Yes, yes. Can you hear me still? Yeah, I would like to come in definitely on the last question, and I think the questioner was quite right. The source of the problem is, what do we mean by best interests? And again, the UN committee tried to help us out with General Comment 14, where it gives something of a checklist of the kind of things that ought to be considered in assessing best interests. I guess the problem is always going to be that it will be case specific. Each child's situation will be unique, and the totality of that child's situation should form part of a best interests assessment. I guess there are two bits. I'm familiar with legal systems that actually have statutory checklists, some quite short, others very long, some that don't actually define best interests and leave it to the courts ultimately to assess the whole thing. If there is not a clear statutory list, then usually what seems to happen is that people who are writing textbooks about family law come up with unofficial checklists based on previous cases. I know I've done it. Scotland, for example, has very little by way of statutory definition of best interest. So me and everybody else who writes about family law has put together what they think is a sort of checklist. The courts, of course, are not bound by that, but it may be helpful. The essence is, I guess, it's always going to be a rather loose concept because it's so case specific. Not sure if that helped the questioner at all.
You want? Yes, you.
Yeah, it was like a search for the right answer. Who has it? Who gets to decide? And it depends a little bit on the arena, because if you go to Norway, there is a claim that we have had this provision embedded into legislation all the way back to 1896. However, it has meant something different, of course, throughout time. Corporal punishment was normal in 1896. Let's not be judgmental. It's just wrong today to do that, what they did. And they thought that was best because you had to discipline children. That was what was best for them. So they had the best interests in mind. That's how they defined it into legislation in 1896. And then you had the 1953 model, which is greatly where children are kind of seen through the lens of psychoanalysis, where you had to have them within the family. And so then you get child protection established in Norway, so to speak, because then you had to make sure that they could live within the family, because that's where children were to develop. That was in their best interest. So you had to go in and help them before before a care order had to be issued. And then it developed into what in the 90s, where we got a lot more focus on the child itself. It was not a human rights approach in the beginning of the 90s, but what was best for the child had to be within the realm of the child itself. You had to see the child because it felt kind of, if you were taken out of the home, it fell apart. The logic of the previous legislation about the family, it fell apart. So we had to start to think about the child as a rightful kind of legal entity in itself. We didn't do that earlier. And in 2014, we kind of had a twist and a turn where the best interests were supposed to be understood in a cosmopolitan manner. That's when it actually, we had a certain legislative amendment in 2003 as well, where we kind of incorporated the Convention on the Rights of the Child into the law on child protection. But it wasn't until later that it became more explicit that it was the cosmopolitan explanation of what was in the best interest. And then you had to go to the Convention on the Rights of the Child to obtain some meaning of what that principle was about. And so the discussion should be focused in, at least for Norwegian, from the Norwegian point of view, to what does the cosmopolitan version of the best interest involve? What is it? And we know certain things about what that principle stands for, in my view. And one really important point there is that it is fundamentally indeterminate. We don't know. And that should inform you as to what you actually expect from that principle. So you don't know the interest of that particular child in front of you. And so you should perhaps not have a check. Which is the opposite. But it's yeah.
Unfortunately, we're running out of time. There's going to be a panel also on children's rights in a few minutes. So I suggest we take the break now and try to be back in a few minutes so we can try to start in time. Thank you. But we had 45 minutes. So Elaine, thank you so much for being with us on screen. Unfortunately, we couldn't see you that much, but it was very nice hearing you. Thank you to Hege and Oscar on behalf of the Transform. And thank you to all of you for being here.
Thank you.
Next time you come, you will get another lot.
Perfect. Perfect.